Hello friends, welcome to the special lecture Symbolic Expression, and in the studio as sign language expert we have Manisha Sharma with us. And in the earlier lecture which we are doing on the series History of India from 1700 to 1950, we talked about the Indian Constitution and the establishment of the Republic, and we talked about the various kinds of concerns which were there in the Constituent Assembly, that how Constituent Assembly was being formed during the colonial period, and how British they played an important role at that point of time, where we find that how the Constituent Assembly was framed, then the role of the Muslim League in terms of it not joining initially and then joining it and then leaving it, and the role of the various national movement leaders, those who were part of the Constituent Assembly, who wanted the assembly to be more diverse in nature. And this has to be seen in the background of the kind of challenges which were there in Indian society at that point of time. And we find that partition had just happened, and the displacement and resettlement was a concern. And India, as it was under the colonial rule, we find that British had left it very poor, and how the drain of wealth from India, giving no kind of attention to the agriculture industry sector. We find that many of the sectors which could have developed in India did not develop because of the apathy of the colonial rule, and how the idea of nation building was also important at that point of time. And we find that the economic development was to be undertaken within a democratic political structure as well, and a democratic and civil libertarian society was to be created among the people, those who were illiterate at that point of time. And as we also are concerned that constitution, when it is talked about, then the basic features and the basic structure of the constitution is being talked about. And in 1973, in judgment in the Keshwananda Bharati case, it was being argued that the basic structure of the constitution cannot be altered. And D.D. Basu, who is a constitutional expert, he said that the judgment laid down that there are certain basic features of the constitution which cannot be altered in exercise of the power to amend it. And if a constitution amendment act seeks to alter the basic structure or the framework of constitution, court would be entitled to annul it on the ground of ultra vires. And S.M. Sikri, who was a justice, he in a way talked about the basic features as the supremacy of the constitution, republican and democratic form of the government, secular character of constitution, separation of powers between the legislature, executive and judiciary, and the federal structure of the constitution. And apart from that, we also find some of the features like the principle of free and fair elections, the rule of law. They are also in a way to be in way or incorporated as the basic features in that sense. And D.D. Basu has argued that the objectives specified in the preamble, judicial review, freedom and dignity of the individual, unity and integrity of the nation, principle of equality, concept of social and economic justice, balance between the fundamental rights and directive principles, independence of judiciary and effective access to justice. All of them, they are very important in the framework, that how all they play an important role in the life of the country as well. So, constitutional experts, they have in a way interpreted the various articles which are there in the constitution. They have in a way widened the scope of these articles by in a way interpreting them, and these features definitely have played an important role in terms of providing a sense of justice to everyone in India. And we also see that how a number of changes they were being brought about at different points of time. During emergency, we find that it was being declared that there shall be no limitation on amending powers of the parliament, and that no constitution amendment can be called in question in any court on any ground. But Supreme Court later in Minerva Mills versus Union of India, it reaffirmed the applicability of the doctrine of basic structure by holding that judicial review is a basic feature which cannot be taken away by amending the constitution. So, we find that how even during the times of emergency, we find that how there were certain kind of limitations which were being imposed on the constitution, and it was being also argued that these kinds of amendments which were being done by the parliament, they cannot be questioned as well. But court in a way decided that the doctrine of the basic structure is supreme, and judicial review is also a feature which court has to adhere. And so these kinds of arguments, they were being made by the court at that point of time, and it was also being argued and has been in a way understood as well, that how court can declare ultra vires any amendment to the constitution if it believes that it would affect or alter any of the basic features of the constitution. So in that sense, this kind of a position, which is the present position and which is also an acceptable position as well, and we find that constitutional experts like Basu, they have argued that the substantive limitation founded on the doctrine of basic feature has been introduced into the constitution by the judicial innovation as well. So how judicial innovation or intervention has definitely played an important role in terms of defining the constitution. And we find that when one is talking about the features of the constitution, when one is talking about the preamble of the constitution, then it can be seen as a basic philosophy of the constitution, which we find, and how it was also based on the objective resolution which was introduced in the Constituent Assembly, and it contains the ideals and aspirations of the people, because it talks about the sovereign, socialist, secular and democratic republic. Those secular was added later in 1976. And we find that how preamble in a way states that the people of India in the Constituent Assembly made a solemn resolve to secure to all citizens justice, social, economic and political liberty of thought, expression, belief, faith and worship. So we find that how preamble is central to the constitution, where it is in a way communicating what constitution contains, and how it was trying to bring or trying to secure for the citizens justice in every way, whether it was economic, social or political, and how individuals, they should have liberty of what they want to do. We have also seen that the equality of status and of opportunity is also being talked about, and how it is to be promoted among everyone, and the fraternity assuring the dignity of the individual and the unity of the nation. So these kinds of features or ideas, they are there in the preamble as well. And we find that how the concept of justice was given priority as compared to liberty, equality, fraternity and to social and economic, as compared to the political justice was deliberate. So we find that the concept of justice is very, very important, and how when justice will be delivered, when it will be given, then only we will be able to realize the objectives of the constitution. And we see that how, apart from D.D. Basu, other constitutional experts like Subhash Kashyap, he says that the order of the words, they indicate that the concept of social and economic justice was perhaps considered the most fundamental norm of the Constitution of India. So experts, they have also seen that how the constitution makers, they put those words, and the order of the words also indicates their importance in that sense, that how the social and economic justice was the fundamental norm of the Constitution of India, and how various kinds of articles and various kinds of ideas, they were being incorporated, keeping in mind these kinds of concerns. We also see that constitution also has the fundamental rights, and how these rights are the individual rights, and they in a way help, in a way seen as enforceable in the court of law. But at the same time, we have to see that they are not absolute, they have certain restrictions as well, and they can be seen as a limitation on the power of the state. And W.H. Morris Jones, he has argued that not only the fundamental rights represented the advanced democratic thought, but was also a convenient way of setting at rest the fears of minorities as well. So fundamental rights, basically they are the individual rights, and how if they are in any way infringed by the state, then the individuals can go to court in the framework of the right to constitutional remedies, and during the normal times. And we find that how fundamental rights, they were being seen in a way claimed by the British, that they had stayed on India to protect the minorities who would otherwise be suppressed by a majority. And leaders like Sardar Patel argued that it is for us to prove that it is a bogus claim, a false claim, and nobody can be more interested than us in India in protection of our minorities. Our mission is to satisfy every one of them. So, the British claims in terms of minorities, they were being rejected by the leaders of India, and how these leaders they rejected the bogus claims made by the British at different points of time. We also see that these fundamental rights, whether the right to equality or right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property which was being taken away earlier, and right to constitutional remedies, all of them they have played an important role in terms of providing the rights to the individuals, and any kind of exploitation against them cannot take place, and they can take recourse to court if their rights are being infringed by the state in the normal circumstances. And we also see that various rights, all these rights, they have also played an important role in that sense, in terms of improving the confidence of the masses in the constitution as well. And a number of debates, distinctions, they have also been made with regard to the fundamental rights, and many times how courts they have intervened and how they have widened the scope of the fundamental rights. And fundamental rights, they also provide some kind of a protection to the individuals from the arbitrary state action, and they also provide protection against the other private citizens as well. And we find that Article 17, it abolished the untouchability, and Article 15 2 says that no citizen shall suffer any disability in the use of shops, restaurants, wells, roads and other public places on account of his religion, race, caste, sex or place of birth. And so, we find that any kind of a distinction on any basis has been rejected by the constitution, and how it made a number of efforts in terms of removing the various social evils which are there in the society, untouchability being one of them, and how forced labor was also in a way prohibited by Article 23 of the constitution. We find that apart from the fundamental rights, the directive principles of the state policy also have played an important role in the evolution and the maintenance of the ideals which were associated with the national movement, and how we find that though these directive principles are not enforceable, but they are seen to be the positive obligations of the state, and the principles which are there in the directive principles could become justiciable as and when they were incorporated into laws, and they constitute the social and economic democracy as well. In the Article 38 it says that the state shall strive to promote the welfare of the people by securing and protecting as effectively as may a social order in which justice, social, economic and political shall inform all institutions of national life. So, we find that directive principles, they definitely play an important role, though they are not justiciable. An individual cannot go to court if directive principles they are not being enforced by the state, but at the same time there are certain kinds of guidelines to the state, that how the state has to ensure adequate means of livelihood to all its citizens, and also has to see that how the equal pay for equal work. So, there is no distinction between the various sections of the society, or either in the framework of the gender or any kind of other issue. We also see that how health of workers, children and pregnant women was to be protected, as it is also part of the directive principles. And we find that when equitable distribution of the material resources will take place, then the society would become more equitable in nature. And it also says that how the concentration of wealth and the means of production is to be avoided, so that they can be equitably distributed as well. And directive principles, they in a way express the hope that within the 10 years of the adoption of the constitution, there would be compulsory primary education of children up to the age of 14 years, and common civil code was also being desired. and state had to take a number of measures with regard to organizing the village panchayats to improve the standard of living of the people and nutrition. Free legal aid was to be provided and promote the educational and other interests of the scheduled caste and tribes and other weaker sections. So, we find that the directive principles of state policy, they are also asking the government to take care of the weaker sections of the society and make special measures or take special measures to promote their welfare. And it was not only restricted to the individuals. We find that directive principles, they are there in a far wider scheme, and they talk about improving the environment and how to safeguard the forest and the wildlife of the country as well, and how in the international framework as well they have to promote international peace and security, and how good relations in the framework of the just and honorable relations between the nations are to be maintained, and we have to inculcate respect for the international law and treaty obligations which have been of which India has become part of. So, these things, they have also been talked about in the directive principles. So, so that some kind of an image of India at international level can also be maintained, and we also see that how it also encourages the settlement of the international disputes by arbitration. So, in a way it tries to communicate that how when India is living in the world where various countries are there, then the rules and regulations which have been framed, they are to be followed in that context, and we find that important Supreme Court judgments and amendments, they continue to redefine the relationship between the individual rights and the social good, and this kind of a changing relationship is the proof of the ability of the constitution and other institutions, and in that sense that how it has helped flourish to adapt to the needs of new generations and to respond to forces in the changing world. And Austin has argued that the tension between the two represent the classic dilemma of how to preserve the individual freedom while promoting the public good. So, this kind of an idea whether fundamental rights and directive principles of state policy, they are in consonance or they are in opposition to each other. So, we find that how fundamental rights are justiciable and people can go to court with regard to that, and on the other hand directive principles are not justiciable, one cannot go to court with regard to their enforcement. But we also see that fundamental rights are individual in nature and directive principles are talking about the public good. So, some kind of a balance between them is to be made. Apart from that, we also see that the term secular and socialist, they were being added by the 42nd Amendment in 1976, and there is a debate with regard to the meaning of secular in India, because word secular is a western concept from which term secular is borrowed in a very different one as well, and we find that in West the outcome of the struggle between the church and the state led to the separation of the two. Church was allowed to decide on the religious rituals, a state was to regulate the secular affairs, and how this was being incorporated in 1976 through an amendment. And there is a debate as well that how what was the need in that sense, that how the secular character of the Indian polity was evident even before the partition of India and the independence of India and thereafter as well. And we also see that the fundamental rights, they include the prohibition of the discrimination on the grounds of religion and the right to freedom of religion, including the freedom of conscience and free profession, practice and propagation of religion, freedom to manage the religious affairs, freedom to pay taxes for the promotion of any particular religion, and the freedom on attendance at religious instruction or religious worship in certain educational institutions. So, we find that how definitely the right to freedom of religion played an important role in that sense, and we scholars like Radhakrishnan, Dr. S. Radhakrishnan, he has argued that he holds that no religion should be given preferential status of any unique distinction. No group of citizens shall arrogate to itself rights and privileges that it denies to others. So, he in a way is trying to suggest that all religions are to be treated equally, and any kind of a disability or discrimination to any person on the basis of religion should not be there, and they should be free to share to the fullest degree in the common life their beliefs which are there. So, secularism, as here as he has argued, is defined is in the accordance with the ancient religious traditions of India. And when one is talking about constitution, the chairman of the drafting committee, Dr. B.R. Ambedkar, he explained that why the term union of states was preferred over the federation, in that sense that union of states, the drafting committee wanted to communicate it as a union of states, in the sense that India was to be was not to be a federation in that sense. Federation was not the result of an agreement by the states to join in a federation, and that federation not being result of an agreement, no state has right to secede from it. So, federation is a union because it is indestructible. So, he in a way tried to define that why the word union was preferred instead of federation, because there was no right to secede. And though we find that how country has been divided into different states because of administrative convenience for that matter, but how people they struggled together, and how we find that India only has one citizenship. So, in that sense India is a union of states, and how the constitution played an important role in terms of minimizing the conflict between the union and states by clearly specifying legislative powers of each. And three lists, the union list, and the concurrent list, and the state list, all these three kinds of list could be seen. And we find that the center has overwhelming financial powers, and how states they are dependent on grants and aid on the center. And we also see that many times state and the center they might have different ideological complexities or situations, and even then we find that the survival of the federal system could be seen, and perhaps it is to be found in the coexistence of the state government with the sharply divergent ideological complexities. And when one is talking about constitution, when we find that despite so many challenges in 1940s, India was able to come up with such a kind of a constitution which was talking about taking care of all the sections of society, the ideas of nation building. They were also there in the constitution in the framework of the directive principles, and how individual liberty was also being given through the fundamental rights. And the various features of the constitution, like preamble, which is seen to be the basic structure of the constitution, it also contains the philosophy and the important points of our constitution. So, with this I would like to end the discussion. Thank you very much.